Good evening, everyone. Welcome to week 11. We're very much at the business end of the semester. I'm aware that there's a lot going on for everyone at the moment, not the least of which the fact that the assessment 2 is due tomorrow evening. So we're keeping this workshop a little bit lighter, trying to bring together a bunch of themes that we've talked about right throughout this semester, but also bringing it back to thinking about the future and the way in which technology and e-commercial law will impact legal careers of the future. So we've got our usual tutorial problems that we can work through, but just for something a little bit different, what I thought we'd do is kick off with a couple of discussion questions that are a little bit more on the fly and that sort of draw together a few different ideas. So the first question that I wanted to pose to you guys was whether we can think of electronic and traditional transactions as equal. In what ways are they the same? But also in what ways are they different, and what are the consequences of those differences?
For the most part, they're given a lot of the same weight now, but sort of speed of transactions and potential for loss along the way, and sort of hacking as opposed to just lost in the post make for very different treatments of misplaced electronic documents, I guess.
Yeah, absolutely. So the sort of formally they're the same, but in practice there are important differences. The cybersecurity one is an interesting point, and I will revisit that later on in this workshop, because that is a really important thing for us to consider as well. The way that the potential problems that doing things online or whatever, the challenges that arise are very different to traditional methods of exchange. Absolutely. Yeah. What else?
I agree with what Sarah has to say, and just to build on that, I think certainly the speed and the availability of online transactions. So you've gone from maybe bricks and mortar business hour type transactions to transactions that can occur globally 24/7 at any time. And then there's also the issue of identification. Are you really dealing with the person that you think you're dealing with, or are you being catfished?
Yeah. Do they call it catfishing outside of the specific dating context? I don't know. But yeah,
I use the term broadly.
But yeah, it's a good point, and it's so the scope of commerce has obviously expanded drastically with globalization, but the way that technology really facilitates that as well is really quite incredible. And yeah, we do see that from a regulatory perspective, the kinds of behaviours that we need to capture when we think about the Australian commercial law and things like that truly are global in scope now, where previously they didn't have to be. Knowing who you're dealing with obviously is trickier with the internet, but also when we think about the products that we're dealing with, perhaps, and things like that. It's we've talked in previous weeks about sales by description and things like that. That's with online shopping and things like that. That is much more important than it ever had been. Absolutely. Anything else? Any other thoughts? In terms of sort of the idea that an electronic contract is just as valid or is the equal of a traditional contract, or e-signatures versus a pen and ink signature being functionally the same, but for an electronic signature needing express consent for that to be a particular method of executing the document and things like that. Do you think that undermines the validity of electronic execution, or at the end of the day, it's all a bit of a wash?
In my experience, certainly being able to have people sign things electronically is a lot more convenient. But I can certainly see the risks there from a fraud perspective. But then again, people have been forging people's signatures for years. So we've had risk in the traditional method just as we have risk in the electronic method. So yeah, I think the convenience maybe outweighs. I don't know, maybe you could put some more measures in place to manage some of that fraud risk. But yeah, I think this certainly provides a lot of benefits.
Yeah, absolutely. And I mean, the measures is a good point, because the measures for preventing fraud in those scenarios have to be different, right? With pen and ink, you can ask someone to show a form of ID or something, whereas online or with electronic execution, sort of via email, sending around the document, that sort of thing is not always possible. So the regulation side of thing has to be different as well. Absolutely. Any other thoughts on that one? And I mean, it's an interesting discussion point to lead this workshop, I think, because it's, in some ways, it is quite a small issue in terms of the broader scope of e-commercial law. But what it does really highlight is the way that technology is changing legal practice. And it's something that you guys are going to absolutely have to grapple with in your careers, more and more so. You know, we've got no idea what kinds of technologies will evolve in the future. And equally, we've got no idea what that will do to legal practice. But we do know that we will have to adapt to that. And so I thought we could then lead on to a second sort of quite broad question, which is around, what do you think technology will mean for your legal career? And in asking that, I realise that there's many different legal career pathways. We're not all going to go into private practice. There's all sorts of things that you can do and call that a legal career. But what I think it's worth thinking about now, what impact will technology have on the way that you do your work? Because, you know, thinking about it now means that when you go out into the big, wide, scary world, you've already thought about it. You've already started to prepare for those kinds of challenges that might arise. So what do you guys see as the big issues in terms of technology and practice, or whatever you do with a law degree?
Jacob, I think there'll be an expected standard of proficiency with electronic tools. Like if I'm looking in the short term, and then what I foresee is the longer term. So I think in the short term, there's certainly an expectation that you'll be able to use online platforms as we've all been thrust into them with this whole COVID situation. I will say that the years I've spent studying on Zoom have just made everything feel kind of normal, actually, having Zoom meetings and doing presentations through Zoom, using different platforms. Whereas some other people that I work with who don't use this medium at all have actually struggled with it a little bit. So from that perspective, I think that's important. Longer term, I will say that I'm really concerned about where artificial intelligence and all those sorts of things are going with some of the roles and functions that traditional lawyer work did, and how we've had AI replace certain things like, you know, case citators and all those things that we love, but then how much further is it going to go in being able to construct arguments or, you know, affidavits and all those sorts of things? You just don't know. It's limitless. And I'm worried about that from a career prospect perspective when, you know, as a law grad, there's just so much competition anyway. Having to compete against a machine probably isn't something I want to be doing in the future.
Yeah, absolutely. The sort of the digital proficiency stuff is interesting, because, yeah, as you say, you know, this is technology that you guys have been using for some time now, and it has been interesting watching my colleagues at other universities madly scramble to move to online teaching, and yeah, here we are relatively unchanged. But it's interesting. I'm looking into a study at the moment in terms of clients' digital literacy and their willingness to engage in video conferencing with lawyers rather than in person and consultations and things like that, and the concerns and the reasons why clients don't feel comfortable video conferencing with a lawyer rather than traveling, thousands of kilometers or hundreds of kilometers sometimes to see them in the office. So yeah, absolutely, that's the being proficient in technology, but also knowing your way around it, and knowing from a client's perspective what are they expecting from the technology as well is really important. And the AI thing is really, really critical as well. So we can probably have an expanded discussion of that in a moment too. But I'm interested to hear other thoughts before we do that.
I'm not too worried about robots coming to take any legal jobs per se. But there's going to be a necessity not just to know the law, but be able to, I suppose, also use technology, just because we're in a technological age. To me, it's with law, it's going to need that objectivity and also a bit of subjectivity when it comes to the facts of a case, because you need to be able to understand the facts and look at things from different standpoints, whereas I suppose with computers, it's very hard for them to do that. I don't know. I guess I was just looking at it from a different way.
Yeah, absolutely. So there's, there is an argument to be made that, what really makes a lawyer is their ability to think critically and creatively, which is what I've been trying to encourage you guys to do all term, and hopefully, that's been something that's been encouraged of you all throughout your studies. And those are skills that a machine either can't do or can't do very well. And so there's an argument to be made that that creative human input is something that the robots won't replace. Perhaps, absolutely. Any other thoughts there? The automation stuff is interesting. I wanted to share with you guys. So this is the 2020 Chief Legal Officers Survey. So it's a survey that runs every year from the Associated Commercial Law people. And it's 1,000 chief legal officers from, I think it's about 50 different industries and organisations right around the world. And every year they get asked a bunch of questions about, what are the main legal issues they face? What do they see being the challenges of the future and things like that? And I think the results are quite interesting from this perspective too. What's worth bearing in mind is that this was completed from September to November of last year, so before COVID hit, because I think that will itself have a bit of an impact on results for next year. But nearly 70% of chief legal officers expect that the use of AI in legal technology applications will accelerate. I think the other 31% are probably dreaming a bit there. But then some other interesting ideas as well. Around 60% think that industry-specific regulations and data protection and privacy rules are the big legal challenges for commercial law in the future. And only about 60% are confident that their organisation can keep track of those changing regulations. and less than that, only 54% are very or moderately confident that their organisation is ready to tackle new risk threats. More than half plan to adopt new technologies or have done so already. And about a third expect to do more outsourcing to law firms rather than in-house work. So if we take sort of the package of that, of those results, we see the broad gist of it is that use of technology in the legal space is on the rise. Use of technology in commercial settings is also on the rise. And the people who are really at the cutting edge of that see that intersection is really critical. The way that we regulate that space is going to be probably the bread and butter of commercial lawyers for a long time to come, which might be good news for you guys. Another way of sort of presenting that information is they were asked, what new issue has your board of directors been asking you about this year? And the big themes that emerge are around cybersecurity, risk, data protection, and things like that. Some of those themes that Sarah was talking about earlier about, e-commerce versus traditional methods. So really what this does, I think, is highlight that you guys are, I suppose, on the right track when you think about what will technology mean for your careers. But having confirmed that, I suppose, the next thing to think about or to discuss is, well, what do you do about it? We know that AI probably will have a big impact on the way that lawyers work in the future, but what are the kinds of things that you can be doing now to prepare yourselves for those challenges in the future? It's probably, I don't know, maybe it is something that you've thought about, but it's probably not something that you've really had the opportunity to consider. So I wanted to, I know that most of you are at the end of or towards the end of your study. So, as a bit of a coming of age discussion, what are your plans? How do you deal with the challenge that AI will present in the future? Which is a big question for a Thursday evening in week 11, I know.
Yeah, when it comes to figuring out what to do towards the end, it can be a bit tricky on its own. Mm-hmm. Just the world we live in at the moment. Like, after I finish this subject and trusts, I'm done. So I'm coming to that realization I need to figure out what to do with it. And yeah, like I've been reading articles online that have been getting mixed signals. Both law graduates will have a good time finding jobs after everything that's happened, and then another that says we're going to have a bad time finding jobs. And then looking at it from an AI perspective, I don't think practicing as a lawyer or a solicitor or anything along those lines, those aren't too in danger. It's more along the lines of things like administrators, even just initial, what's the word I'm thinking of? Initial meetings with clients.
A consultation?
Consultation, that's it, yeah. Even just initial consultations, they might get left behind, because then there'll be a process where you talk with the computer for that amount of time instead, so you're not using solicitors' times. So then that means either A, there'll be more time for solicitors to work on the case, or B, because we don't need the solicitors for about this percentage of the process, we don't need as many because there's less of a load. So there's like two ways of looking at it.
Yeah. So absolutely. So I suppose the first step in addressing, what can you guys do to sort of, future-proof yourselves is to think about, well, what can AI actually do in a legal setting? And there's some sort of kind of chatbot style consultation is probably, even if it's just to direct someone's inquiry to the right person and things like that. It's definitely one potential application of AI that we'll see. moving into the future. What are some of the other uses that we think we'll see?
I guess I'm not as optimistic as James is, so I want to have some of that optimism rub off onto me. In my space, what I'm seeing AI doing, so I work in workplace relations, so I sort of interface with the Fair Work Commission. And so one of the things I know that they're looking at doing is seeing if there's an AI way that they could get parties to, assess the merits of their case and then also engage in some sort of negotiation. Whereas at the moment, parties will generally engage an advocate or an agent, or in this case, I'm in-house. So what I think I can do to try and get on the forefront of that is to see what value can I add around to that. So if the power is going back into the hands of the parties, is it more about reframing my offering to be about strategy, how to best engage with the AI, how to properly articulate your case? I think overall, we're just going to have to be adapting to what the future brings and not hiding under a rock and suggesting that it's not going to impact us. That's not a criticism, James. It's me just simply saying that I want to keep my eyes on the horizon and see what's coming, and then see how I can repackage and reframe my offering to I guess have a point of difference and to add value to where the law's going.
Oh, it'll absolutely have an impact. There's no denying that. I was just off the top of my head, I couldn't think of anything. I was just trying to keep it to the firm sort of area, but there's a bunch of other places it'll definitely affect. Everything can be, as my parents always said, your job can always get taken away, whether that's by someone else or a computer or a machine. So you got to be good at what you do.
Yeah, absolutely. There's heaps to unpack there, and we should do that if for no other reason than to give Mo a bit of cause for optimism. Before I sort of jump in with some thoughts, was there anything you wanted to add, Sarah?
I mean, I suppose for me it's a bit of a different perspective in that I have doubts on Mo's idea of the AIs being able to replace anyone, because there's always the issue that you won't program everything you need into it. Because to manage to get absolutely everything you normally get out of a human in multiple considerations in an AI requires a massive amount of program. And so in the same way that you mentioned, it couldn't necessarily replace the creative construction of an argument. It could be very beneficial in just finding associated research, because the search engines at the moment are a basic thing for finding keywords in relation to what you're looking to argue about. But they're also limited in which words they search within the document. And an AI might be able to make a more broader search for that, which would be really helpful on the other hand, particularly if it could, keep records of organizations in particular areas. It would save on the time needed to spend to do extra research. So I think it's sort of, for me, it's a bit of I don't expect development to get to the point of being able to make people obsolete within my lifetime, no matter how fast that it advances, simply because I don't know that they'll be able to make the computer processes big enough to handle it within that time period. But at the same time, I think it could be really useful in other ways of supporting, I suppose, the work that you do in law.
Yeah, absolutely. All really great points. And I think that what does make this sort of an interesting area is that, we're speculating about what the future holds. So, there is room for a lot of difference of opinion. Is AI going to be this fantastic research tool that makes all our lives easier, or is it, going to be quite depressing and take everyone's jobs? It's probably in between somewhere. But I think a couple of things that, hopefully will be of benefit to you guys, being sort of at the cusp, at the end of your studies, and then, thinking about where to go next and what to do and things like that. automation in government is huge, and it's not just in workplace relations, it's all across government. It really is something that they are looking very heavily into, and it's something that they're not doing a very good job at the moment. You guys, I'm sure, will have followed the sort of the robo-debt issues of the past few years, and that all arose because the AI programming was not very good, and it didn't pick up the things that it needed to pick up. And so certainly from a government regulatory perspective, that's definitely something that they're looking at doing. And there's plenty of potential application for that in the commercial law setting. Thinking about checking competition mergers, compliance with the credit code, all those sorts of things. There is definitely going to be a lot of teething issues in the early days and years of it. So in some ways, AI will probably produce more work in the early days, because there will be so many mistakes made that real people will have to come along and fix them. So that might be a cause for optimism, get a few feet indoors and things like that. The teething problems that will come with AI will create, depressingly, it will create a lot of problems for people, but it will also create a lot of work for lawyers to try and fix. We also need to think about, well, if that's sort of the direction things are going, as Sarah said, someone needs to program the AI. Someone needs to tell the AI what it's looking for, what it's wanting to do. And so people who are well placed to do that, who have a bit of a background at least in the programming side of things, and obviously with a strong legal knowledge, are going to be in huge demand. So if you find yourselves twiddling your thumbs at a loss with what to do in the next few months and years, picking up a little bit of programming will be infinitely helpful, because you've already got that legal knowledge. And so someone who can do both is going to be very, very well sought after in the years to come. The other thing that's sort of interesting in terms of pushing where this goes is, yes, legal research will be made a lot easier with the adoption of AI. A lot of this sort of, what's going to be interesting is whether it goes further in terms of drafting up contracts and documents and things like that, and especially things that are a bit more routine. Will probably eventually, the AI will be able to catch up to that, and so it will just be a matter of hopefully having a person cast their eye over it to double check it before it goes out. But we've already got the capability for you feed an AI program heaps of, and I can tell you this at the end of your studies so that you don't use these powers for evil. You can feed an AI tons and tons of books and journal articles and essays on a topic, and then it can spit out an essay on that topic using everything that it's learned. It's not always very good, but it's that learning process that the AI is starting to be able to do that's really powerful. And the potential for that in terms of drafting up a letter of advice or something is probably really going to be where the boundaries of AI get pushed for quite a while. What we won't see, I wouldn't think, is that critical thinking, that creativity in coming up with a novel, persuasive legal argument. That's, it's going to be very hard for a machine to take that away. But for some of the more basic stuff, it wouldn't shock me if in the years to come, the AI can at least get some of the way there. And so in terms of thinking about sort of future-proofing yourselves, being able to be on the sort of the programming side of things will be really helpful if you can figure your way around a computer. Being able to really demonstrate your creative, critical legal thinking skills as being something that's irreplaceable by a machine, really important too. And then sort of the types of things that Mo said around, you know, if people are going to have to deal with a machine in terms of dealing with government for a lot of things, being able to advise clients around, well, you know, these are the keywords that you should definitely include in a document, and things like that. There will still be scope and a market for that potentially. So you guys are definitely on the right track in terms of thinking about, well, what is AI going to be capable of, and what does that mean for me, and what can I do to make sure that I'm still competitive in that environment. So, you know, those are just some, I guess, a bit of gratuitous advice that I've got. But I'm interested as well whether that discussion has prompted any further thoughts from you guys as well, because, you know, this is a huge space in terms of the future.
I think reflecting on that slide you had up before, Jacob, around what the chief legal officers are being asked about, I can certainly see an opportunity there around that cybersecurity and all of those things that are going to come with that, you know, electronic way of doing things, even with AI, like you said, the work that's coming through. So it does help with the optimism, absolutely. And it's actually really refreshing to hear Sarah and James's perspectives, because, you know, we're all in the same boat. So to see their outlook is really helpful for me as well.
Excellent. That's good. That's good. That's why we have these conversations. Yeah, the cybersecurity stuff is interesting as well, because it's, you know, how do I put this? It brings with it a whole range of issues as well, you know, and there's AI itself will probably have a role to play in that space too. But there's also, I think, shall we say, a political dimension to this, in terms of, you know, what are the threats to cybersecurity, where do they come from, how are they used, all that sort of stuff. And so there's cybersecurity is not just the raw, you know, this is how little I know about computers, the raw firewalls and protections that you've got in that space. It's also, there's a bit of tact and nuance and creativity in terms of thinking about, well, how do we manage this space? How do we navigate the regulations that will inevitably come through in all of this? And so, yeah, that's something that AI will struggle to deal with as well. So there's definitely space there as well. And I think that's a nice segue into our next sort of discussion point. So AI was a huge theme from the CLO survey. The other one was in terms of keeping up with regulations, specifically around data protection and privacy rules and cybersecurity, but more broadly, just keeping up with regulations. And you've seen throughout this course that, you know, the regulations are constantly changing to meet, you know, changes in commercial behaviour, to better protect consumers, to better regulate the way that credit providers operate, all that sort of stuff. So, and you know, hopefully this is something that has been sort of brought to your attention already. But if not, what are some of the ways and strategies that you can use to keep up with changes in regulations and rules throughout your career? You know, the Australian commercial law is not going to stay the same way that it has, as we've discussed it in this unit. how will you know when it's changed if you're practicing in this space? Subscriptions to source providers. Yep. Can you think of any examples?
I mean, for me, it's like the WA legal council and stuff like that, because they obviously update when they update the legislation. They send out notifications and everything like that. And you can also to some of the publications that publish like recent case law, like innovative case law normally gets its own sort of separate publication. Makes it easier to keep it updated on how that stuff's changing.
Yeah, absolutely. So yeah, it's sort of the legislative alerts are a really good strategy. You know, you're going direct to the source. So that's really good. Any other ideas?
I know that with some regulators, you can actually subscribe to them, like if they've got an online offering. I guess coming back to my example in workplace relations, I've subscribed to the Fair Work Commission. They send out bulletins to practitioners with changes to like practice rules. Then there's also industry publications, like Sarah was saying, where they send out, you know, major decisions and, you know, hold discussion points on certain things too.
Yep. Yeah, absolutely. Yeah, most sort of government bodies will do that. The tax office do it a lot, from my perspective. And yeah, some of the sort of commercial sort of forms, places like Thomson Reuters alerts and things like that will. And what's good about them, and you know, even sort of more, I guess, informally, things like Lawyers Weekly and things like that. What's good about them is they come with a little bit of commentary as well. And you know, you should always, of course, go directly to the primary source with these things, but sometimes it is useful, just, you know, when you're living a busy commercial lawyer life, it is helpful sometimes to have someone pull out the key points for you as you go along, so you know what to look out for as well. You can also subscribe to alerts from the courts too, although some of those can be a bit finicky in terms of, you know, you don't want every judgment that the court's done. So being able to tailor that, some of the courts are better than others. And social media as well can be useful too. You know, you guys will have your own networks, you know, that you've established here at CQU, and then as you move on as well, you'll have your professional links, and so places like Twitter can actually be a useful way as well of keeping up to date with how things are moving along sometimes too. The reason I thought that was an interesting thing to discuss is that that's in itself an interesting use of technology in the commercial law setting. You know, most of these methods are, you know, comparatively recent developments. And so just thinking about how much easier that makes it for us is really useful as well. But are there any other thoughts on that one? That didn't need to be a huge discussion point, unless there was anything else that people wanted to raise. And of course, you know, in 10 years' time, the AI will pick up all the alerts anyway, so you may not need to worry about them. Okay, well, let's have a brief look at the tutorial problems. We might just we'll probably only have time for the first one. So, and I expect that given that the assessment's due tomorrow, there's probably not been much time to have a think about that one. But Jennifer wants to attend a rock concert and goes to a ticketing website. She has to click a box indicating her acceptance of the venue's terms and conditions. She does so without reading them because she would have had to leave the website that she was on, and so she's worried about missing out on the tickets if she does that. Later, the concert is cancelled because of bad weather. She finds that the terms and conditions preclude a refund. Advise Jennifer. What's going on here?
I guess the key things that jump out to me around legal issues is firstly whether the terms and conditions are binding on Jennifer, given the nature of the transaction and how it played out. And then, of course, secondly, because we've just covered it in the term, I'm thinking about the ACL, because Jennifer's a consumer and she's made a purchase of a consumer good, or service essentially. So I want to know if there's a remedy for her under that statute.
Yeah, absolutely. So, especially given that this seems to be a standard form contract, will the ACL apply? In the chat, Sarah's added as well, electronic signature is valid agreement, but whether the term is a valid exclusion. So we're probably happy that clicking the box to say, yes, I've read the terms and conditions is valid, but whether the actual, you can't get a refund if we cancel for bad weather, whether that's valid is potentially an issue. And I'm not necessarily disagreeing, but is the electronic signature itself valid agreement?
Sorry, Jacob, do you mean the ticking of the box? Is that what we're referring to as the signature?
Yes.
Well, when I looked at this case, I know you tell us to avoid jumping to conclusions, but when I read the case, because I'd worked through the course materials, I went straight to the case that this referred to for me, which was the eBay case. And so around the validity of ticking the box, whether the terms are binding, it really comes down to whether the provider did all that was reasonably necessary to bring the terms to the other party's attention. So it's binding if the provider met that threshold, essentially, but then that's when the ACL may intervene. I don't know, Sarah, what are your thoughts given you raised that point?
For me, because the way electronic signatures are accepted as sort of a valid indication of agreement, and most people don't tend to read them when they are like, I need to have that agreement and have agreed. I think it's normally considered a valid enough agreement to function as the electronic signature, which is why my main concern would only be the point on whether the exclusion term they are trying to rely on is valid, because it may not necessarily be valid to say, just because bad weather, we're not giving any refunds.
Yeah, absolutely. So, I mean, I was mostly just looking for a little bit of detail and authority, and talking about eBay International and Creative Festival Entertainment would lead us to say that there's not an issue with the ticking of the box as signaling agreement and bringing in the terms of the contract. As Mo says, what is at issue is potentially, one, whether the website had done enough to bring attention to the terms, and then perhaps laid on top of that, are the terms themselves actually fair? So on the first issue, we do probably need a little bit more information. It might depend a little bit on what the layout of the website is, but you know, the fact that she saw, here's the link, and chose not to click on it because she thought she'd lose her place in the queue, and, you know, apparently didn't know how to open up a second tab. Probably that one's going to be on her. And so moving on then to the operation of the Australian consumer law, what do we think about excluding refunds for something like concert cancellation due to bad weather? Do we think that that's going to be okay? We've got a no from Mo. Why not?
I don't have the particular provisions of the unfair contract terms in front of me, but I know there is a provision that goes to whether one party can, you know, avoid performance, whereas another party can't. And I think it goes to the heart of the fact that the contract is for access to a concert. So if the other side can not provide that concert and there's no refund or remedy for the purchaser, I think that that's an unfair term under the ACL. If I had the particular provisions in front of me, I'd refer to them, but that's sort of where I'm heading.
Yeah. Anyone else want to jump in? So yeah, probably what we're thinking about is around sections 23 and 24 of the ACL, looking at unfair contract terms. And in particular, section 24 looks at a term being unfair if it causes an imbalance in the party's rights and obligations, and it's not reasonably necessary in order to protect the legitimate interests of the party who would be advantaged, so the concert providers, and it would cause detriment, whether financial or otherwise, to a party if it were to be applied or relied upon. And so probably, you know, from Jennifer's perspective, what the argument is that, you know, sure, you can cancel the contract, the concert due to bad weather. That's, you know, that's reasonable, but it's not reasonably necessary to keep the money from the ticket under those circumstances. That doesn't protect the legitimate interests of the concert holder. What would be reasonable would be to give the money back, given that the services are not being provided. Thoughts on that argument?
But Jacob, what if the provider has incurred some costs that they can't recoup? Is this just going to be like a domino effect of everyone claiming a refund? Someone's going to be stuck holding, you know, a loss at the end of all of that.
Yep, as well. And see, here's the thing, right? That it comes down to a question and a debate about what's reasonable, right? And this is where we, as critical and creative lawyers, do our work that the robots can't replace us from. You know, probably there's an argument to be had that keeping some of the money, it would be reasonable. You know, and it depends on the costs, depends on all sorts of things. But, you know, you can get, they refund 90% of the money that was paid, and they keep 10% because that's a reasonable amount to cover their costs that they can't themselves recover, or that aren't, you know, covered by their insurance or things like that. So, you know, it really would turn on a discussion and an argument about what is reasonably necessary in order to protect their legitimate interests. And, you know, that's, like I said, that's where we do our work as lawyers, potentially. Does that make sense? Yep. So yeah, to sort of recap on that one, we're reasonably happy that the ticking the I accept box can be a valid form of executing the agreement. It's probably going to be Jennifer's own fault for not reading those terms and conditions. You know, there's sort of the classic contractual arguments about if the terms were so onerous, special attention should have been made to them, all that sort of stuff. But luckily, we probably don't have to go down that route because the ACL is a bit more clear and certain and geared towards benefiting the consumer. And we can say, you know, this is a standard form contract and the terms in that contract are unfair from Jennifer's perspective. So an interesting interaction there between commercial consumer law that we've already looked at, and also the way that sort of technology layers in over the top of that. And that's, you know, that's going to be an evolving space as well as the technology changes and improves. We'll have a brief look at the second one, the second question. It's not really e-commercial at all. It was more of a sort of a last problem for the semester sort of summary thing. So luckily we don't have much time left to spend on it because there's not much time to spend on it. Joel was a clerk at Automotive Accessories and had authority to draw checks up to a maximum of $100 for petty cash purposes. Normally, Joel filled out the check and the office manager and owner then signed the check. While both of them were away at a week-long conference, Joel signed a check for $1,500 as agent for my principal, Automotive Accessories, adding the notation PP to pay for a shipment of automotive accessories from Repco. Discuss. So is that check going to probably be valid? And as I said, you know, it's not really related to commercial e-commerce. We're thinking instead more broadly about the course as a whole.
So the key things that jump out at me with this one, Jacob, is that he acted outside of authority. So Joel was only authorised to a maximum of $100. He signed this check for $1,500. But the other challenge there for the Repco is that he's held himself out as the agent, as though he has authority to sign off on that. So I think Repco will probably want to be pressing that to get their money, whereas Automotive Accessories may argue that, you know, it was unauthorized. So I think it's one of those problems where you can run an argument either way, and on balance, I don't know which one would get up.
Yeah. Thoughts from Sarah and James on, do you think one side or the other would get up? And if so, why?
I suspect that the Repco will have a stronger argument simply on the basis of previous dealings. He's previously been the agent in the process, admittedly not signing, but, you know, in that process, he has previously been held out as agent by the business. So that's normally sufficient to give the idea of implied authority or ostensive authority insofar as making deals that bind the business.
Yep, absolutely. So we're thinking classic apparent authority. and as it appears to Repco, this is all valid. Joel is, as it would appear, acting with the authority to sign this check for the $1,500 amount, and then so in terms of enforcing that, that's that will probably go Repco's way, and then of course the manager and owner, well, more so the owner, would have potential to pursue Joel for breaching his authority and acting outside the scope of his authority, right? To sort of bring that question back in our last 2 minutes, to bring that back to e-commerce, and I think that this touches on some of the issues that we touched on at the start of this workshop. What if this wasn't a check? What if this was, an online bank transfer of funds or something like that? Do you think that the issues change? And if so, how? Or is it, the fundamental principles of agency still work even in that sort of online setting?
I mean, if it was EFT, then the business would have no grounds to stand on, because if he wasn't allowed to make electronic fund transfers to their bank account, he shouldn't have access to it.
Yep. So we see perhaps, it's, and this is sort of, the broad point that perhaps I wanted to end on was technology absolutely is going to change the face of commerce, and therefore has to change the way that commercial law operates. But the principles that underpin commercial law, these ideas about bailment and agency and consumer protection and all that sort of stuff, those principles don't change. And the law will adapt to those new technological settings. And so, in addition to, I suppose, the more concrete strategies that we've talked about around, dealing with AI and keeping up to date with law changes and things like that, is really sort of honing your skills in thinking in order to adapt to these new technologies, using your understanding of commercial law or any other field of law, really, and being able to have the solid principles down pat so that you can apply those in the new and novel settings that will arise over the next decades of your long and happy careers, perhaps. We might end on that note. Good luck to all of you getting your assessments in tomorrow. I'll try and have them marked by next Thursday, but we'll see how we go. Of course, next Thursday is going to be the discussion. Like we did in week 6, we'll have a chat about what worked and what didn't work and what we thought and things like that. So I'm looking forward to seeing you all then. But yeah, the most important thing to end on is good luck getting your assessment in tomorrow. And of course, there's still time to get in touch if you have any questions or concerns. But for now, good evening and goodbye.
Bye.